We read a few minutes ago that the law prohibits discrimination on the basis of disability by places of public accommodation. So what is a place of public accommodation? What I brought up here is what's actually in 42 USC section 12181 7A through L. And here we have an inn, hotel, motel, or other place of lodging, except for an establishment located within a building that contains not more than 5 rooms for rent or hire that is actually occupied by the proprietor of such establishment as the resident. So, I mean, we're talking here about basically a small bed and breakfast where the owner actually lives there and there's not more than 5 rooms available for rent. So, but other than that, we are talking about hotels generally. A restaurant, bar, or other establishment serving food or drink, okay? A restaurant, bar, or other establishment serving food or drink is a place of public accommodation covered by this law. A motion picture house, theater, concert hall, stadium, or other place of exhibition or entertainment. An auditorium, convention center, lecture hall, or other place of gathering. A bakery, grocery store, clothing store, hardware store, shopping center, or other sales or rental establishment. Laundromat, dry cleaner, bank, barbershop, beauty shop, travel service, shoe repair service, funeral parlor, gas station, office of an accountant or lawyer, pharmacy, insurance office, professional office of a healthcare provider, hospital or other service establishment, a terminal depot or other station used for specific public transportation, museum, library, gallery, other place of public display or collection, a park, zoo, amusement park or other place of recreation, nursery, elementary school, undergraduate or postgraduate, private school or other place of education, a daycare center, senior citizen center, homeless shelter, food bank, adoption agency, or other social service center or establishment, and a gymnasium, health spa, bowling alley, golf course, or other place of exercise or recreation. Sorry I read through all those. It was a bit tedious, but I just wanted to go through it very clearly to make sure that everybody has an opportunity to see exactly what types of businesses are covered by this law. So if you're watching this and you own a restaurant or a grocery store, or, really, I mean, the list goes on and on here, a laundromat, an amusement park. If you own any of these types of businesses, these businesses are covered as places of public accommodation under the law. Oftentimes, in my own, again, anecdotal experience, the types of businesses that will be sued will be restaurants, bars, stores, so a retail establishment is here somewhere, right? So these are the types of businesses that get sued a lot, at least as it relates to physical barrier issues. Other types of businesses tend to get sued in website cases, and we'll discuss that in a minute. But, take a minute to look at this list and to go to 42 USC section 12181 and look at it and see whether your business is a business that's listed on here, because if so, then it's a covered entity. And this really covers a lot of small and medium-sized businesses in this country. Landlord and tenant responsibilities. So this is another very important issue, because the ADA doesn't only apply to the businesses themselves, it also applies to the landlords who rent the businesses their property. So landlord and tenant responsibilities. Both the landlord who owns the building that houses a place of public accommodation and the tenant who owns or operates the place of public accommodation are public accommodations subject to the requirement of this part. As between the parties, allocation of responsibility for complying with the obligations of this part may be determined by lease or by other contract. Let's break this down. A landlord who may be a commercial landlord that doesn't own any business that it itself has opened to the public, is nevertheless a place of, or a public accommodation if it is renting a commercial property to a public accommodation. So if you're a landlord, or if a company is a landlord, it owns commercial properties, it rents a space out to a restaurant. Now, the landlord is not in the restaurant business. The landlord does not service the public generally. The landlord is just renting this space out that it owns to a restaurant. The landlord is nevertheless a public accommodation because the restaurant is a public accommodation. And so oftentimes in these, almost always, in these in ADA architectural barrier cases, you'll see the landlord sued along with the tenant. Now, sometimes the landlord will have a provision in its lease saying if there is an ADA lawsuit, or if there is an allegation against the landlord for violation of law as a result of the tenant's use of the property, that the tenant will indemnify the landlord. So that's why it says, as between the parties, the allocation of responsibility for complying with the obligations of this part may be determined by a lease or other contract. Now, that lease or other contract doesn't change the law. It can't alter the law such that the landlord is no longer a public accommodation. It's still a public accommodation, but it may have its own contract claims against the tenant by virtue of the fact that it was sued on the basis of the tenant's use of the property. I hope that's clear. The bottom line is that landlords generally have some type of a clause in commercial leases that cover this, so that they can look to their tenants in the event that they get sued, since it's the tenancy that has made them a public accommodation subject to the ADA. Okay, I hope all that is clear enough. Let's move on here to the next slide. Okay, exemptions and exclusions. Who does the law not apply to, even if they are running the type of business that would otherwise be considered a place of public accommodation? So we're looking here again at the regulations, part 36, section 102 rather, sub E, which says exemptions and exclusions. This part does not apply to any private club except to the extent that the facilities of the private club are made available to customers or patrons of a place of public accommodation, or to any religious entity or public entity. Okay, let's break this down a little bit. So, if you're a private club, you are not open to the, well, let me not say you, because I'm not speaking about anybody here individually. Okay, so 36.102, 28 CFR section 36.102 sub E says exemptions and exclusions. This part does not apply to any private club except to the extent that the facilities of the private club are made available to customers or patrons of a place of public accommodation, or to any religious entity or public entity. And what I really want to focus on here is private clubs and religious entities. So the exclusion of private clubs is important if you're running a private club that is not open to the public and that is not serving a place of public accommodation, is closed only to the members. That is an exclusion that's listed under here. Now, whether or not a particular private club is subject to this exclusion is something that that club would have to consult a lawyer on to really explain all of the aspects of the facility and exactly how their club runs, but that's a possibility. And then there's a religious exemption, and of course that's a very basic church and state issue, that the ADA does not apply to religious entities. So churches, synagogues, whatever the case may be, obviously the government is not going to exercise authority over religious places of worship, etc. But again, if a religious entity has a question about whether or not it is subject to the ADA, whether or not its parking lot has to be compliant, whether or not it needs a ramp, it really needs to consult a lawyer in order to determine what parts of the religious entity may or may not be subject to the religious exemption, but that is definitely a possibility. So private clubs and religious entities may well have an exemption, again, subject to talks with their own legal counsel, but that is something that is written into the law. Okay, next, another exemption. Places of public accommodation located in private residences. When a place of public accommodation is located in a private residence, the portion of the residence used exclusively as a residence is not covered by this part. But that portion used exclusively in the operation of the place of public accommodation, or that portion used for both the place of public accommodation and for residential purposes, is covered by this part. The portion of the residence covered under paragraph A of this section extends to those elements used to enter the place of public accommodation, including the homeowner's front sidewalk, if any, the door and entryways, the hallways, the portions of the resident interior and exterior available to or used by customers or clients, including the restrooms. So again, if there's a business and it's in a home, the portions of the business that are used as part of a public accommodation have to be accessible and have to comply with the ADA. Other parts do not. And what comes to my mind immediately as an example is maybe a bar that the owner lives on top of on a second floor. So we have a building that is being used on the bottom floor as a public accommodation and obviously would have to be treated as a place of public accommodation. But if only the owner lives upstairs and nobody ever goes upstairs other than the owner and his family, it's not used for for any type of public use, that would not also then be converted into a place of public accommodation by virtue of this part. But again, if anyone who's running a business that is mixed in some way in the building with a private residence should really consult a lawyer and make sure that the correct places in the building are accessible and do comply with the ADA, and that the other parts that don't have to comply are well known based on whatever the business is and whatever the makeup of that building is. But this is an exclusion that's available as a possibility to people in this situation.